Our topic this morning is judicial independence. I don't think that I need to say very much about why that is important. Those countries that have judicial independence, we value it, we benefit from it in many, many ways. And of course, countries which do not have judicial independence, well, you experience what it's like when judges make decisions that simply favor the powerful and ignore the interests of the poor and the marginalized and so on. Our two guests this morning are two presenters. Alison Tilley and Mbekezeli Benjamin work for an organization called Judges Matter. And Judges Matter, wonderful organization that specializes in keeping an eye on the judges. How are the judges selected? How are they behaving? Is there political interference? Are they carrying out their jobs without fear or favor, and so on? And as I'm sure that they will tell us this morning as part of their presentation, at the moment in our country, we have some quite interesting judges who have stepped out of line in various ways. So we're grappling with this question of judicial independence in a wider sense, also judicial probity and good and bad behavior from some of our judges. So without any further delays, I'm going to hand over to Alison and Mbekezeli.
Oh, sorry, I had muted myself. Thank you so much, Mike, for the introduction. I'm sharing my screen, and I'm hoping that people will indicate if they see my screen.
Yes.
Could you can see my screen? Okay. So my name is Mbekezeli, and I'm here with my colleague, Alison, and we come from the organization Judges Matter. So today we are going to have a conversation. We plan to have a conversation with everyone where we share our experiences from the different corners of Africa that we are, because the intention of this session is not for us to come as experts, which we are not, but we hope to learn as much from you as we hope that you will learn a few things from us. So the idea behind this session is to speak about the concept of judicial independence. For many of us, it's really an abstract concept, which we might not find relevant in our daily lives on top of all the other troubles that we have. But it remains a very important concept to understand in our unique context, and which is why we think this conversation is timely, as Mike said. It's so important, regardless of where you are on the continent. So that's basically what we want to achieve today, is to have a conversation with you about judicial independence, and hopefully we'll learn what it is. What do we look out for when it comes to judicial independence? What are the threats to judicial independence? And how do we, as civil society, protect the independence of the judiciary? Now, before we start, I just want us all to have, I'm hoping rather that we have a piece of paper in front of us. That is important because what I would like all of us to do is to note down things that we believe enforce judicial independence in our countries. So what are the key elements that support judicial independence in the countries that we are? So wherever you're sitting now, or whichever country that you believe you are from, what are the elements of judicial independence can you identify? Please note them down. And at the same time, please also note down what are the threats to judicial independence that you see in your own country. So wherever you're sitting now, wherever you are on the continent, what unique threats are there to judicial independence? The purpose of this exercise is so that you take stock. You take stock of what's happening in your own country. You don't need to have done extensive research, really. It's something that you can probably see daily on the news, if not, if you don't encounter it on the streets. So those are the kinds of things that we want you to note down and which we hope you will share with us during the course of this presentation. This presentation is intended to be a learning session, an exchange session. We are taking a tour. We want to go from Cape Town in South Africa to Lusaka in Zambia to Lagos to Cameroon. Someone mentioned that they are in Cameroon, so we also want to go to Yaoundé. So we want to learn as much as we can. So even if you're in Kinshasa, please let us know what judicial independence looks like in that corner of the continent. Right? So we are good to go. And just on housekeeping, if you could pop any questions that you have in the chat box, we will try and get to those questions as much as we can. And if you need any clarity, please also say so in the chat box, and then we will stop and look at it wherever we can. Are we good to go? And I've noted that we are translating this into French as well. So if there's any issues with language, please also indicate that for us, and then we will try to respond to it as much as we can. So I tend to speak very fast. So if I happen to speak very fast, please also indicate that I slow down. I'll try as much as possible to do so. So we start. So a little bit about us. So we are Judges Matter, and Judges Matter is a civil society transparency project, we like to call ourselves, and our work is dedicated to monitoring the judiciary in South Africa. So we monitor the appointment of judicial officers, which includes judges and magistrates. We monitor the discipline of judges. So what are the disciplinary processes that exist in the judiciary? We also monitor how judges are governed, or the judicial system is governed in South Africa. This is in different countries, they do it differently, but we also monitor that. And how do we do this? We do it through applied research. So we do research on issues that affect the judiciary, and we monitor them on an ongoing basis. We happen to be based at a university, at the University of Cape Town. So we are in touch with academic researchers who assist us with legal and policy research. We also have a strong advocacy presence. We try to introduce issues into the public arena on the judiciary. So any issue that affects the judiciary, we try to make noise about it, to draw the public's attention to it, and why it matters to ordinary people's lives. You'll be surprised at how often people think that judges exist in their own worlds when they affect almost every aspect of daily life. And then finally, we try to provide easily accessible information for people to follow themselves what's happening in the judiciary, so they themselves can monitor wherever they are, and hopefully if there are any concerns, they bring them to our attention. So that's in a nutshell what Judges Matter does. You can follow some of our work on our website, judgesmatter.co.za. You can also follow us on Twitter and on Facebook. And then the Judges Matter team includes myself, Alison, who'll speak later, and a third member of our team, which is Zikhona. And Zikhona today is dealing with other issues, because at the moment in South Africa, it's a really busy time for the judiciary. So we've decided to split, and so that we can cover those issues. Are we good so far? I'm hoping my pace is not too fast. So we like I said, we're going to have a conversation today, and part of that conversation will be answering a few questions. These are questions that I've drawn up with the assistance of Mike, but I'm sure that you will have other questions. So I'm hoping you'll pop those in the chat box. But the key questions that we'll discuss today include what is judicial independence, the concept of judicial independence, how do we understand judicial independence in the African context? As you know, Africa has a unique culture, unique history, unique traditions, which impact on judicial independence and how we understand it. And so I'm hoping that we'll be able to tease that out as well. We will then speak about the importance of judicial independence. Why do we need it? Why is it so important? We'll speak about the key elements of judicial independence. What do we look out for in practice to say that this is judicial independence and what is not judicial independence? And then what are the red flags, threats to judicial independence in a democracy? This is where I'm hoping that we'll have the greatest conversation, because there's quite a lot happening on our continent. And so it's important that we speak about it and we reflect on how we deal with those challenges. And then finally, we'll speak about the role of civil society in protecting judicial independence. And here, I'm going to rely a lot on you as participants to share those insights, and let's help each other. Let's build solidarity on how we protect judicial independence and eliminate the threats that we will collectively identify. So we begin. What is judicial independence? So here I've tried to pull together what I think are the key elements of judicial independence. The list that I've put up here is not an exhaustive list. It's not everything that is to be said about judicial independence. There's plenty of things that I've not included, which might be very relevant to where you are, but I'm hoping that this is a good place for us to start. So firstly, there is a fundamental principle. The fundamental principle is that judges must decide legal disputes fairly and impartially and guided only by the law. So that is the fundamental principle when it comes to judicial independence, that the people that we take our disputes to must be able to be fair on all of us, regardless of who we are, how much power we have in society, or how little power we have in society. They must be able to decide on issues that we take to them in a fair and transparent and impartial way. And then secondly, we look at the judiciary as an institution. So the fundamental principles relate to judges as individuals. And then the second leg of judicial independence is that the judiciary as an institution must be kept separate. So it must exist separately from the other branches of government. So the other branches of government are Parliament, or the legislature where you are, and the executive. The executive includes president, government ministers, bureaucrats in the civil servants, that those people form part of the executive. And the judiciary must be independent from these two other arms of state. Sometimes they call this the principle of separation of powers. So each arm of the state, so the judiciary, the executive, and the legislature, each have powers, and they must exercise those powers independently of each other, but holding each other accountable. They call it checks and balances. And then the third idea of judicial independence is that judges must be free from outside influence. And the influence might come from public sources, and it might also be private sources on the judiciary. So when we think of public sources, we're thinking of politicians, government, ministers, officials within state departments, officials within parastatals, who may want to influence the way that judges decide cases in a particular way. The private sources of influence on judicial independence might be business or business people who are very powerful. It might be individuals, so very prominent individuals in society who might want to force judges to decide in a particular way. Those people have have an impact on judicial independence, and a key component of judicial independence is to protect judges from the influence of those people. This also includes the media and civil society organizations. And here, civil society organizations are quite broad. It is trade unions, it is churches, it is other associations in society, including sports bodies. They can have an impact on judicial independence. And so these people, judges must be protected from these outside influences. And then many writers, academics, lawyers recognize that judicial independence is a key ingredient in a democratic, free, and open society. So a society that protects human rights, a society that has the rule of law, has judicial independence as the cornerstone of that society. So that's, in a nutshell, what judicial independence is. I'd be keen, or I'd be interested to hear what you understand judicial independence to be, and we can share our ideas and learn from each other. And then, as I said earlier, judicial independence is important in a free and democratic society. It is the cornerstone of democracy, in fact. But more to the point, because judges interpret the laws that govern our lives, it is important that they must do so fairly, impartially, and without fear and favor. So the concept of judicial independence speaks about this. So judges may only act fairly if they can be able to independently come to their decisions, only guided by the law. They may act without fear, and they may come to their decisions without fear if they feel that they are independent in coming to their decisions. So basically, the reason why we want judges to be independent, or the judiciary to be independent, is because we want judges to act without fear or any prejudice to any person. So they must all treat us equally and must see us equally. And another important aspect here is that judges protect human rights and they protect our civil liberties. And so we want them, when they do so, to act fearlessly and to act independently when they come to those decisions. So if I, for example, am a farmer and the government is suddenly taking my farmland or my livestock or my produce, if that is not in terms of the law, I need to have an independent arbitrator who will decide a dispute between me and the government. So judicial independence is important here because it will protect me as the farmer who is less powerful than the government. Judges must be fearless in looking at the law and deciding in my favor. If the law favors me, judges must not be afraid to do so. So judicial independence is really important in our day-to-day lives. And then the other aspect of judicial independence is that it operates alongside judicial accountability. So we give judges a lot of power to decide issues that affect our lives, but they must do so within a framework of accountability. So they must be able to justify why they take the decisions that they did. So they must act independently, first of all. And how do we know that they're acting independently? They give us reasons why they take the decisions that they take. So if, for example, a judge decides that in a dispute between me as a farmer and the government is correct, the judge must explain why they said that the government is correct. And I must be satisfied that it is the correct decision. And if I'm not, then I need to take it up to another level on appeal or on review, depending on where I am on the continent. So I'm just going to pause for a few seconds for us to just understand this part, because it is quite important. And then I want to move to the next question that we have. To emphasize why it's so important is our continent, Africa, is unique. We have a unique history. Many of us were colonized, and so we have a history of colonialism. And so some of the concepts like judicial independence, they often come from Western traditions, but they have application in an African context. So we need to understand that. So in most African countries today, judicial independence is protected in the constitution or the basic law of that particular country. But in most countries that I've seen, judicial officers or judges are given a special status in society. They wear particular dress, some of them they wear robes, others they wear wigs and all of that. And they occupy a special status in society, which I think helps in enforcing this idea of judicial independence. And the special status obviously will depend on the different countries and the different legal systems that apply in that particular country. But one issue of judicial independence that tends to be unique in the African context is that often courts or court buildings exist within a community based on, let's say in most African countries today, they have court systems that operate in their countries. Many of those court systems were built by the colonial government that existed at the time, whether it's British or French, Belgian or German, they built their own courts. But when they built those courts, they've already found ways of dispute resolution amongst the communities in those countries. So in many African countries, or in many traditional communities in Africa, we have a dispute resolution system that exists within the governance system, like your local chiefs. The local chief is not only, let's say, the head of the area, but they often are the ones that play this dispute resolution mechanism. So in some countries, we have something called khoros. In others, we have tinkundla, or we have izinkundla, wherever we are. But these systems are there to resolve disputes, but they are fused within the other governance system. So they don't necessarily exist independently of the governance systems. So this is a tricky one to explain, and I struggled a bit to come up with a simple way of doing so. So if you have questions about this aspect, please feel free to raise the question. But the key point that I wanted to communicate is that in the African context, judicial independence is not neat, because we don't have, in some communities at least, we don't have a judiciary that exists separately from the local chief or the local headman. So the local chief is where we go to resolve our disputes. In many rural areas in South Africa where we're based, even in urban communities, people still go to their local chief when there's a dispute or between neighbors or between family members. Instead of them going to a Western civil court, they'll go to a traditional chief who will try to use a more mediation or more sort of level playing field in trying to understand the dispute and try to retain the relations between the two people involved in the dispute. So our model as Africa as Africans, our model of resolving disputes is a little bit different. And so it does have an impact on judicial independence. So when you are reflecting on how judicial independence impacts where you are, please also reflect on this aspect. And then next, we look at the key elements of judicial independence in practice. So in most countries, the courts are organized in a system that is separate from government or the legislature. So there is a court there's a court system that exists. It usually goes from district level to regional level, and then all the way to the Supreme Court. That is one of the elements of judicial independence, that there is a system of courts that exist. The other is that there is a constitutional responsibility given to judges to interpret the law. So Parliament makes the law, judges interpret the law. And in most countries, this is recognized in the basic law of the country where you are. And this is a key element of judicial independence. And then in some countries, like in countries that are based on the English Westminster system, such as countries like Nigeria, like South Africa, parts of Cameroon, Kenya, and Zambia or Zimbabwe, they also have an element of judicial review. So judges can review decisions of Parliament and the executive and test whether they comply with the Constitution. And this is protected in the basic law, and this is a strong element of judicial independence. The other element of judicial independence is that there is a clear process of appointing qualified judges. So usually in many countries, there is an independent body that interviews judges and recommends them for appointment to the courts. In other countries, they don't really have an independent body, so the Minister of Justice plays a role in appointing qualified judges, but there is some sort of process that exists. There is a strong element of judicial independence. And where it does not exist, that is a reason to be concerned a little bit. And then another element of judicial independence is that the salaries or the benefits of judicial officers, including judges and magistrates, is guaranteed by the law. So judges and magistrates are given a guaranteed income, which they earn for the time that they are judges or magistrates. So they are given a set salary that they receive every month. And then in some countries, it's even included in the law that judges' salaries may not be reduced. So this is also to protect their independence. Because the reason, the idea behind this is that if a judge is worried about their salary, this might impact how they decide on a particular case. So if, for example, a judge is worried that if they decide against the government, then the government will reduce their salary, then that judge is not independent or cannot act independently. So in many, many countries in Africa, the salaries of judges are guaranteed, but in practice, this has a little bit of a complication. In some countries, we are aware that judges are not given a guaranteed salary. At times, they are not even paid. We've heard cases where for you to go to a magistrate or a court, you need to first pay the magistrate for them to decide. And for us, this is a threat to judicial independence. And then another aspect of it is that judges and magistrates are appointed for life. They have what is called security of tenure. So the idea, again, similar to the income, is that when a judge is appointed for life, then they never have to worry about losing their job or having to look for a job instead of focusing on the work of resolving disputes or deciding disputes. This is an important element that is written in the basic law of most countries, in the constitution of most countries, But again, the issue is that in practice, this is not always recognized or observed. So I'm hoping that if this happens in your country, you will share your learnings or your observations with us, and then we'll have a discussion about it. And then just going towards the end is that, like I said, the incomes are guaranteed. There is security of tenure, so your job is guaranteed as a judge. But in some countries, the budget for the judiciary is done separately. It is protected from the rest of the government budget. And that is to ensure that the courts operate independently and judicial independence is recognized and protected. So that's another aspect of judicial independence that is important, and that relates to the finances. Now, moving a little bit away from the finances issue, is that similar to the appointment of judicial officers, the removal of judicial officers has an impact on judicial independence. So how judges are appointed and how judges are removed has an impact on judicial independence. So for you to observe that judicial independence exists in the country that you are, you'll notice by how judges are removed. There should be a clear process of how a judge may be removed, which means that a judge cannot simply be removed when the minister or the president says so. There should be a process that, for example, investigates any complaint against a judge, and that complaint is dealt with by an independent body, an independent panel. That panel will decide on whether or not the judge did commit misconduct or not, and then whether or not the judge is removed. In South Africa today, we are grappling with that issue. We've never had it in the past where a judge is about to be removed, but just a few days ago, the Judicial Service Commission, which is an independent body, announced that one of the judges must be removed from office due to misconduct. So there is a clear process. Of course, there's plenty that can be improved in the process, but it's just one example. And then another unique aspect of judicial independence is that there are legal protections that are built into the law that protect the work of judges or judicial work. This is often called contempt of court, or there are certain crimes called scandalizing the court. So to protect judicial independence, there are provisions in the law which says that you may not defy or you may not violate a decision of a court. And I'm not sure how many of you are aware, but the former president of South Africa is currently in jail for doing that, for violating a court order and being in contempt of court. And that is an important aspect of judicial independence, because if a court can give a court order and you will not comply with it, then might as well shut down the judiciary because no one else will comply. And so there needs to be a legal mechanism to enforce court decisions. And in South Africa, there is something called contempt of court. In other countries, they call it different things. So I'm speaking a little bit fast, and I'll try to slow down, but these are just the key elements of judicial independence. There are many, many others, of course, like I said, but for now, I think these are useful to help us get the conversation going. And then I just wanted to make an example of the judicial appointments process in South Africa, just to let us understand, to show us how this happens in practice. And at this point, I would like to hand over to Alison, who will speak a little bit more about the Judicial Service Commission and the Magistrates Commission.
Thank you, Mbex, and good morning, colleagues. The judicial appointments process in South Africa is controversial, and I'd be interested in hearing your views on how it works. Normally, well, certainly in many of the jurisdictions across the continent, judges appoint other judges. When South Africa became a democracy in 1994, it was felt that this was a serious problem that apartheid judges had been running the legal system, and that it was a concern that apartheid judges would continue to appoint judges like themselves. And it was felt that we needed to make a decisive break with the past and appoint judges who would be in favor of the transformation of the judicial system to a constitutional state, which had not been the case before. So thinking about this, the idea was then to try and create a body that would appoint judges that would take into account the need for transformation. And it was decided that there would be three groups in judicial appointments. The first group would, of course, be judges, and in the Judicial Service Commission, there is a group of judges. The Chief Justice sits on the JSC and is the chair of the JSC. There is also a judge who represents the other judges, the leadership of the courts, known as the judges president in the various divisions. And in each round of appointments, the judge president for that particular region will sit and usually lead on asking that particular candidate questions. There are also two groups of lawyers. One group of lawyers is directly appointed by the president. There are 4 of those. And then there are also lawyers representing the legal profession. So there are advocates, 2 of them. There are attorneys, 2 of them. And then there is also somebody representing legal academics. But that's not all. And I think this is where it becomes controversial, is that we have politicians that sit on the Judicial Service Commission, and they are divided into 2 groups. The one group comes from the National Assembly, which is our lower house, and then the second group come from the National Council of Provinces, which is the upper house in our parliamentary system. And the numbers are reasonably balanced so that no one group is really able to dominate the commission, but they have to at least get to the point where 13 of the members of the Judicial Service Commission are in favor of any particular candidate. Once the Judicial Service Commission have reached a decision in terms of who the candidate will be, they then forward that name to the president. Where we're dealing with the lower courts and courts all the way up to the Supreme Court of Appeal, there is only one candidate per position, and the president, as a matter of course, appoints that person. When it comes to the Constitutional Court, the Judicial Services Commission sends 4 names forward to the president, and the president may pick one of those 4. When it comes to the Chief Justice, the president is able to make that appointment, although he or she needs to consult with the legal profession and the various constituencies represented on the Judicial Services Commission. The process is quite similar for magistrates. We have a split system with magistrates and high court judges, but the process is relatively similar. The main difference is simply the ability of the Minister of Justice to make decisions around appointments, because there the minister has discretion between candidates. I think at that point, let me hand back to Mbekezeli, and he can take us from here.
Thank you, Alison. So that was just a snapshot of the work that the two commissions do when it comes to the appointment process. And the reason why we highlight it is that it's one of the most prominent times when people pay attention to the judiciary. And this is important in reinforcing this idea that judges must be independent, and so we must all care about how judges are appointed to the bench. So transparency is a key ingredient also in reinforcing judicial independence. And then now we move to the threats to judicial independence. And here I was reluctant, or we were reluctant, to put together a list that all of you will take home and simply just apply. What we want to do is sort of co-create a list. We want you to give us as much as we give you, because I don't think it's possible for us sitting where we are to identify all the threats to judicial independence. But I want to make an example, just one small one of a threat to judicial independence. And the person you see on this picture is a judge, the Chief Justice of Malawi, Justice Andrew Nyirenda. And there was an issue, a threat to judicial independence that happened in Malawi, which was unique and which was interesting. And before it happened, I personally had not thought about this. I thought that I didn't think it was possible, but we saw it happen in Malawi, and this was a concern that was raised, and it actually happened quite recently, about 2 years ago, in about 2019, if I'm not mistaken. So we'll chat a little bit about the Malawi example, but just to quickly go to the examples, the other, threats that we have identified, and we call these red flags because we think they are red flags that should make us all jump up and pay attention to our democracy, because the life or death of a democratic country relies a lot on the courts. So, like I said earlier, security of tenure, so the appointment of judges for life, is an important aspect of judicial independence. So if there is no security of tenure or an insecure tenure, then that's a threat to judicial independence. Irregular income is also a threat to judicial independence. So judges or magistrates not being paid on time, or being paid at different times, or not being paid at all, that's also a threat to judicial independence. And then the process of appointing judges can be a threat to judicial independence. So if the process is obscure, or it's not clearly set out in the law, or if the process is secret, or if it's partisan, so the political party of the day, that's ruling the country, is the one that does those appointments, it's also a threat to judicial independence, because the likelihood of a judge who's appointed through a partisan process to act impartially and independently is very low, considering the way that they were appointed. And here there is a document called the Lilongwe Principles. If you can Google that document, it sets out the model of how judicial appointments should happen across Africa. But it was obvious, the document was drafted by the South African Chief Justices Forum, but we think it's applicable all over the continent. And then the other red flag is that there is no due process for removal from office. So when there is no process for removing a judge, and it is just simply done on the whims or the pleasures of the government or the president or the ruling party, then it's a threat to judicial independence. The example of the Chief Justice of Malawi is one of the most topical ones that I can think of at the moment. And I will, let me just quickly deal with it now. I actually wanted to play a video, but the technology was just not agreeing with us today. So what happened in Malawi is that there was an election, a presidential election, and there was a dispute in the election results. The ruling party took the case to court, and it went all the way through the court system. Eventually, the judiciary or the judges decided that the election was regular and should be set aside. Now, what happened immediately after was that the president, who lost, and his party lost in the court proceedings and in the elections, the president announced that the Chief Justice was going to go on retirement. Now, this effectively meant that the Chief Justice was removed from office. So the president didn't need to sort of fire the Chief Justice. He simply decided that the Chief Justice must go on long leave and he must go on retirement. He must just go, he has accumulated too many leave days and he must simply just take the leave immediately and go on retirement. And now this meant that the Chief Justice was effectively fired, even though they didn't do so in so many words. There was no process, the president simply announced it, and this meant that now the head judge, the top judge in the country, had lost his job without even the courtesy of a consultation. So this is a threat to judicial independence. We can cite many more examples in different countries, and I'm hoping that you'll share some of these. And then the other big thing is corruption. So obviously when judges are being paid to take particular decisions, then or being paid irregularly, so outside of their income, the income that they are supposed to receive in terms of the law, if they are paid bribes, then that's a threat to judicial independence. And there are many examples that we can cite on the African continent on this. And it's, as you would imagine, it's a key threat. And it's not only judicial officers or judges, but also court officials. In some countries, people bribe court officials to make dockets disappear or make cases disappear. And that also hampers, and it's a threat to judicial independence and hampers the administration of justice. Now, the other aspect outside of corruption and paying bribes, it's the influence or interference which is improper. And this influence or interference is meant to influence judges to take decisions for irregular reasons, so reasons that are not in terms of the law. And this influence, like we said earlier, it can come from private sources or public sources. So it can come from politicians, from business people, from corporations, from churches, political parties, other outside groups. And like the example I spoke about earlier in South Africa, the judge who is being impeached right now in South Africa was found guilty of trying to improperly influence other judges. So the threat to judicial independence doesn't only come from external sources, but it can also come from internal sources within the judiciary. So we mustn't look at it as people who are trying to influence judges, but judges also sometimes try to influence other judges to decide in a particular way. And that is also a red flag in terms of judicial independence. And then the other less obvious way in which a red flag to the to judicial independence rather, is the unfair or baseless criticism of judges and the judiciary. So in certain countries, when politicians are not happy with the court decision, they will hold a rally and they will call judges as traitors, as enemies of the people. We see this in Africa, and I can make the example of the Seychelles, where the Chief Justice was threatened and was called names by politicians when she made a decision that was against the ruling party in that country. And even it exists even beyond at the African continent, Donald Trump used to be a regular critic of the courts, especially when court decisions go against him. He used to call judges enemies of the people, and he used to call them as illegitimate. So that's also a threat to the independence of the judiciary. And then the other threat, again, comes internally from judges themselves. When they close their mind, instead of judges acting freely, impartially, fairly, and independently, the judges close their minds to the facts and the law, and they simply decide in favor of the government. They call this executive-minded judges. That is also a threat to judicial independence that we also need to look out for. Now, I'm just conscious of time, so I'll try to move through the next slides a little bit faster than I have so far. But these are just a short list that we have drawn up ourselves. What I want you to do is when you observe the situation in your country, I want you to point out or scribble down on that piece of paper some of the threats to judicial independence that we have not listed here. So I want you to be thinking about what are the unique circumstances of the jurisdiction that you are at that would impact on judicial independence and would be a red flag. So please note those down because we want to hear more about them. And then before we move to those threats, or rather, before we move to what should happen in terms of the protection of judicial independence and what do we do about the threats to judicial independence, I want us to pause a little bit and reflect on the work that we are doing today. So the piece of paper that I've asked you to scribble down is homework that I want you to take forward from now. So going forward, it's something that you will do. But I want also for you to think about it in the context of the work that you are currently doing. So if you are, for example, working at the parish, or you're working for as a parliamentary liaison officer, you must think about ideas or concepts that you will, in where you are, in your space that you are, that you will use to help people understand what judicial independence is and what are the threats to judicial independence that they may encounter, and also think about actions that you need to take to address those threats and to also overcome the challenges that the judiciary in your country faces. So I've given you two pieces of homework. The one is the piece of paper that I want you to scribble the elements of judicial independence that exist in your country. And I also want you to scribble the threats to judicial independence in your country. The second homework that we want you to do is where you are right now, in the role that you're playing in the organization that you are. What can you do to educate people about judicial independence, to help people understand why judicial independence is important and what threats people can identify as threats to judicial independence or the proper functioning of the courts, and what can they do to address those threats? I hope I've been able to explain that properly, because I tend to speak a bit fast. So now I want us to move to the actions that we can take. And again, this is not a list that we want to prescribe to you. We want you to add to this list, to change the list, to delete what you think is not relevant to your context, and to sort of put it in your own words, some of the things that we are thinking about. So one of the things that civil society does, which includes both you and us, is that we are vigilant, that we need to be vigilant and monitor how the judiciary operates. So we need to be present in our courts and to understand how our courts function. This helps us monitor whether judicial independence exists, and when it doesn't, it can also inform what strategies or plans we can put in place to make sure that we protect judicial independence. So vigilance and monitoring is one, and part of the homework that I've given you is to do that, to be vigilant and to monitor. And then once you've monitored and you identified the problem, then you move on to the next step, which is activism. So I've put here activism for legal reform, but it really can be activism not only for legal reform, but it can be other forms of reform. It can be political reforms, where you want the political culture of the country to change to protect judicial independence, or you want to encourage a certain culture that reinforces judicial independence. That will require activism, making people aware of what's happening in their country or in their community. And then the third aspect is legal interventions. And here, legal interventions, I've put it as quite broad to include legal interventions like going to court, but also legal interventions like going to parliament or speaking to a member of parliament to help them understand and pass laws that will protect judicial independence. So legal intervention can be many things, and sometimes it's not even useful. And I want you to think about examples where it may not be useful and you may use another strategy. And then solidarity is the other element, which I think is so important, especially in Africa, in our continent. So solidarity can be regional, can be cross-national, can be international. The example that I made of Malawi and the Chief Justice being removed. So the president in Malawi at the time had decided that the Chief Justice must leave, and he must leave through taking long leave. But what stopped him and what reversed the president, that forced the president to reverse that decision to send the Chief Justice off on long leave, was something called international solidarity. So people all over the world, including those particularly in Africa, made a lot of noise about the injustice of forcing the Chief Justice to leave office early. And that is the kind of international solidarity that we must have. So when you are in Zambia or you're in Democratic Republic of Congo or in Cameroon or Nigeria, you must be able to be the ears and eyes for the rest of us. We must know what's going on in the country through you. And we must build this partnership, this solidarity that will help us ensure that there is judicial independence across Africa, and the threats to judicial independence are eliminated across all the countries where we exist. So wherever you are, we must have a partner in you who will help us protect judicial independence.